And I said, I don't know what you're talking about. So I closed the door and I went the opposite direction. This dude kicked in the door and shot me in my back with a taser that burnt my back.
Pause right here because this is where emotions and law start colliding. The defendant is framing this as a home invasion, but legally the question isn't how it felt. It's whether officers had probable cause and lawful authority to enter. And notice how early the story centers on force. That's setting up a narrative of victimhood before we even get to the charges. Do you think juries respond more to emotion or procedure?
Do that again, Judge. Do that one more time. Put the pen to the camera like you did. Please stop moving your hand to the camera. You're doing that intentionally. Stop doing that.
No,
you were told that I'm not supposed to be in this jail. You know for a fact I'm not supposed to be here. Where's the evidence at?
Okay.
For it on the record.
Turn off the audio now.
Judge, but I'm not playing anything because, first of all, I was on my own property at my own house, and I had to explain to somebody that she has no jurisdiction what I do over my house, or even in my house or on the property or whatever. And she called the police.
All right, we'll see what we've got here with Mr. Seahigh. Looks like it's a new domestic case involving Shannon Seahigh. I'm not really sure why he would have been allowed to have any contact with her whatsoever, given all of his case history with her.
Here it comes, the UCC 1308 invocation. This pops up a lot in sovereign citizen-style defenses. Important clarity, the Uniform Commercial Code governs commercial transactions, not criminal prosecution. Judges don't debate this, they just note it and move on. So quick poll for you watching. Do you think saying the right words matters or understanding the right system?
Mr. Seahigh, it looks like you're back in jail on new charges. There's some of the similar.
Judge.
Yep.
Born on the record, I reserve all my rights under the Uniform Commercial Code, specifically UCC 1-308.
Okay, I'll note that. I'm going to quickly go over the charges with you. You should receive a copy of them and you can just read them yourself. But count one, you're charged with threatening Shannon Seahigh on or about the 23rd day of April 2025 in Butler County, Kansas.
That never happened.
They've not communicated what the exact threat is, but they've alleged that you threatened to commit violence or communicated with her with the intent to place her in imminent or immediate fear.
That's not true.
This is a key legal teaching moment. Probable cause is a low threshold, not proof beyond a reasonable doubt, not even close. It just asks, is it reasonable to believe a crime may have happened? That's why demanding all the evidence at this stage doesn't work. This isn't trial, it's the system checking whether the case moves forward.
Okay, so I'm going to enter not guilty. If convicted, 5 months up to 17 months with the Department of Corrections, up to $100,000 fine has to run.
Judge, since this is the first court date, I would like the evidence to be presented for it on the record.
Okay, so what happens is, and I don't want to read it out loud, but the judge assigned will get an affidavit. Well, yep, I'm assigned. I will get a probable cause affidavit for this arrest. And if there is probable cause, which is something more than a mere possibility, that a crime was committed and you may have committed said crime, then I approve the arrest. But then I go ahead and get your case set for preliminary hearings so that you can have actual evidence with representation, if you want it, for a probable cause finding with...
Judge, but I'm not playing anything because... First of all, I was on my own property at my own house, and I had to explain to somebody that she has no jurisdiction what I do over my house, or even in my house or on the property or whatever. And she called the police on me, and then the police came on my property and said, I don't know what you're here for, but with all due respect, I don't want you on my property. And then they said that, well, we got a call that said that you were being violent. and that you were threatening. I said, well, that never happened, and you don't have to talk to me. You can talk to her.
Notice the loop here, same story, higher intensity. In court, repetition without legal framing doesn't strengthen your position, it can actually signal escalation. And here's the tension: resisting arrest, even if the arrest is later challenged, often creates new charges. That's how situations snowball. Question for you: should resisting ever be worth the risk?
And so anyway, they ended up coming up on the porch, and I opened the door again. I said, I don't want you on my porch. And they said, well, we need to talk to you. We need to find out, And I said, well, I don't know what you're talking about. I'm not violent. Wasn't violent at all. And so he said, well, she wants her keys. And so I said, oh, well, okay. Well, so I gave him the keys. So I gave that dude the keys so she could have them, but she could have came in and got the keys anytime she wanted to, because there are no threats. So anyway, the police officers, after I gave him the keys, he opened the door and said, well, now I'm going to have to arrest you. He said, you're under arrest for threatening. And I said, I don't know what you're talking about. So I closed the door and I went the opposite direction. This dude kicked in the door and shot me in my back with a taser that burnt my back. Do that again, Judge. Do that one more time. Put the pen to the camera like you did. Did you switch something?
Nah, Mr. Seahigh, I did not. Mr. Seahigh.
Okay, well, anyway, that's what it is. And they ended up taking me to this place that I'm not supposed to be at because of how you and other judges and other people abuse me in here. And I really appreciate being in jail. And I want to let you know that for a fact that I'm the one that gave those videos out, and I reported how those babies were getting killed and blood was being spread all over the wall. You've seen the video. You admitted you did on the other court dates.
This is where the math changes. One charge is manageable. 4 charges, especially involving law enforcement, shift how judges assess risk, bond, and control. Body cams matter here. Courts trust recorded conduct far more than competing narratives. At this point, strategy matters more than speeches.
So what is this, Judge? Are you against me having my own property? Are you against me exposing everybody for killing kids? For and on the record.
Mr. Seahigh, all I'm doing today is...
Please stop moving your hand to the camera. You're doing that intentionally.
No.
Stop doing that.
No,
you were told that I'm not supposed to be in this jail. You know for a fact I'm not supposed to be here. Where's the evidence at? For and on the record.
Turn off the audio. Now. Mr. Seahigh, in count 2, you're charged with battery against a law enforcement officer, a Class A person misdemeanor. If convicted, it's a maximum of 6 months, $1,000 fine. In count 3, you're charged with interference with the law enforcement officer, resisting arrest. If convicted, it's a level 9 non-person felony. In count 4, you're charged with threatening a police officer, Cody Marvin. It is charged by the prosecutor's office as criminal threat, a level 9 person felony. If convicted, you could receive 5 months up to 17 months with the Department of Corrections, up to $100,000 fine. I imagine count 2 through 4 are incidents that are caught on camera, as most of the officers wear body cams. Probably not count 1. That will have to be the statements of Shannon Seahigh as to any reporting of any threatening statements by you or actions by you. I'm going to enter not guilty pleas on all of the charges. I'm going to schedule this case for an immediate preliminary hearing at the first available date I have, as well as I'm going to review the probable cause affidavit that should be submitted by today by the prosecutor's office for e-filing, so that I can determine whether or not they had probable cause for an arrest, and then give you a full hearing on May the 28th at 10 a.m. Now I'm going to set bond for you And I'm going to ask for a recommendation from the state.
Yes, Your Honor, and the state is recommending a high bond in this case, as may be determined by the court. As part of special conditions, the state would be recommending no contact with any endorsed witnesses or alleged victims, that the defendant can take prescription medication and no drugs or alcohol. I believe the court has already
And this is the consequence checkpoint. Bond isn't punishment, it's leverage. GPS monitoring, no contact orders, high cash bond, all signals that the court is worried about compliance, not guilt. The big takeaway, courts don't react to beliefs, they react to behavior patterns. And once that risk box gets checked, freedom gets narrower fast.
Indicated some familiarity with the defendant on the record here today. Additionally, this appears to be a defendant with a history of adjudications and convictions the court may consider relevant. Disorderly conduct and at least 2 battery against the school employee adjudications, as well as convictions for disorderly conduct, misdemeanor assault, domestic battery, criminal restraint, and felony interference with law enforcement. Pursuant to the affidavit, this appears to be a defendant who attempted to barricade himself within a residence, as well as threatened to kill multiple individuals, including at least 1 law enforcement officer. And it would also appear that there is another Butler County case, Butler County 21 CR 457, which does appear to involve a journal entry of judgment of direct contempt of court signed by Chief Judge Rickey. And in that case, it would appear that the defendant was convicted of battery, in which the victim was a detention deputy.
Okay. I'm sorry, what was the amount that you're recommending?
Your Honor, the state is prepared to defer to the court as to an appropriate amount. Certainly, the state would not be opposed to a $7,500 cash or surety bond. However, given the particular facts and the history of this defendant, the state does respectfully suggest a much higher bond is appropriate.
Okay, well, I'm going to set his bond at $10,000 cash or surety with GPS. Absolutely no contact whatsoever with Ms. Seahigh, and I assume she still has his child, but I don't know. I'm actually surprised if they were in contact or living together. If he had remained attentive and didn't leave the room here this afternoon, I would have asked him for any statements he wanted to make about bond. And I probably would have asked him about his living situation and any potential no contact orders with Shannon Seahigh. I'm going to assume, since he's not charged with violating a no contact order of any kind, that they were allowed to resume cohabitating, either as he flattened his time or his probation expired or